Mr Chairman, when the cost of those processes becomes so high that people don't go to court to settle their disputes, then there's something wrong with the court system. That's where we've got to in New Zealand. Someone told me, and I haven't had the opportunity to check this yet, but in the High Court last year, I'm told that there are some 350 civil judgments delivered in the whole of New Zealand. Only 350 judgments in cases. I think that's an indictment on our legal system. There are a hell of a lot more than 350 disputes that were necessary or should have had the benefit of being litigated in court. And despite the fact that the number of judgments is down, the length of law reports is the same. And you read a judgment now that comes out of the High Court, and most of them look like they're auditioning to write a new academic treatise on one subject or another. They have become, in my opinion, too often too academic and becoming a little bit rarefied. And I yearn for the day when we have judges who are a bit more robust. Denning, Lord Justice Denning. Yeah, yes, or judges like Justice Holland or the retired Justice Hanson, who keep control of their courts, have a good sense of fairness. They give the parties a hearing, and then they deliver a judgment. We now virtually have no judgments delivered orally in New Zealand. It's very rare for an oral judgment to be delivered. Everyone goes away and they prepare a written judgment. Often that involves time from the judge and also clerks of judges who assist, but in both cases it causes delay. Again, I'm not sure whether it's judges are fearful that they're going to be overturned on appeal if they don't turn over every stone that's been pointed at by one of the parties in the litigation. But for these reasons, our civil processes have become so expensive that they're not being used. And that means that our court system is not serving the function that it's meant to, which is meant to provide people with a non-violent way of resolving their disputes. The quality of justice cannot be divorced from its accessibility. Accessibility is largely a function of cost, and cost is not cured just through legal aid. We must be minimising these costs. We should have legal aid in appropriate cases, but we must be simplifying these processes. So at the Minister of Justice, I'd be interested to hear from his views on that. I know that the court rules are actually the Attorney's rules. The Attorney General actually sets the rules, and I think that it's time for the Attorney to take some control of those rules and to improve court processes so that the amount that people have to get, be it from a loan by way of legal aid or through their own means, is not disproportionate to the amounts of money that are at issue.
Honourable Simon Power.
Chairman, look, just in response